Hello, my name is Jason Lazarus, CEO of Synergy. With me is Rasa Fumagalli, Synergy's Director of MSP Compliance. Rasa has incredibly deep expertise and knowledge in all things Medicare secondary payer compliance. Like me, Rasa is an attorney and she's a Medicare set-aside consultant certified. Rasa, given what is at stake for failing to be compliant with the Medicare Secondary Payer Act, how can law firms achieve total MSP compliance?
Hello, Jason. Thank you for the introduction. I think the key is that law firms need to have a strategic approach to Medicare secondary payer compliance, and they also have to have an understanding of what MSP compliance involves. The place to start is to first off identify clients who are Medicare beneficiaries or who will have a reasonable expectation of Medicare entitlement within 30 months of settlement. When you are signing these clients up, pay attention to this. If a case is also lingering in your office for years, update this information to make sure that you don't overlook people who might have had a 65th birthday while the case was pending. Once you identify the Medicare beneficiaries, you should have a process in place to request conditional payment information from Medicare. You also need to identify whether there are Medicare Advantage plans, Part C or Part D plans at play. Once you have that information, you should carefully audit the conditional payment notices, the liens, to make sure that the treatment really is such where Medicare is a secondary payer, in fact. Another thing that firms should do is they should carefully review the settlement language. Oftentimes, firms are, they're somewhat taken aback when they get 3 pages of MSP compliance addendums to their settlement terms. A lot of times, you're going to have provisions that make absolutely no sense. They might request contingencies, for example, that Medicare review a liability a liability Medicare set aside. That is simply a condition that cannot be met. Another thing that we recommend is that start early. Do not wait to sort this out until you're at the mediation table or going to trial to find out that, whoa, my client is actually on Medicare and they're likely to require future injury-related treatment. If you start early, you can be ahead of the game. Another thing that you should be aware of is that it's really important to make sure that your clients are properly advised about the potential impact of Medicare on their ongoing eligibility for future injury-related care. The decision of what to do really depends upon your client's comfort level with risk and your firm's comfort level with risk. When you have this discussion with your client, or you consult with experts in that area that will consult and advise your client, it's key that you also document your file to show that the steps that you took at time of settlement, at time of disbursement, were taken in compliance with the Medicare Secondary Payer Act. When you follow all of these steps, you can ensure that your firm is compliant with the Medicare Secondary Payer Act.
Great advice, Rasa. So identify Medicare beneficiaries, investigate everything, make sure you are aware of conditional payments, Medicare Advantage, potential liens, educate the client on MSP compliance related issues, and then ultimately document your file. It's so critical. And if you want to learn more and want to have someone that can help you with that, partner with Synergy for total MSP compliance to make sure these sorts of issues are addressed with experts there by your side each day.